All right, this is going to be a long video about a guy by the name of Robert David Neal. If you're not interested in his case, then I don't think you'll be interested in this video. But nonetheless, I'm going to read. He sent me a letter from Terre Haute, Indiana. He's been in prison since 2002, 2003. So what is that? That's like 13 or 14 years. His release date is August the 28th of 2031. I don't think I'll be able to get all the reading done in one sitting, so I'll have to piece these together. I think he got put in prison for some sort of tax fraud, tax scheme. We'll find out together. I tried to do some research on him and find a picture, but I simply haven't been able to find any pictures. Looks like he was a resident of Trophy Club, Texas. His Robert David Neal, his BOP number, he is on BOP.gov in Terre Haute, Indiana, 151-51180. Again, his number is 151-51180. Here is a write-up from the United States Department of Injustice. It was written on October the 27th, 2006. I thought it was 2002. Maybe there's multiple charges. I'm not sure. All right. Here we go. Federal grand jury in Dallas indicts local man on fraud charges. CPA Robert David Neal is former Trophy Club, Texas resident. A federal grand jury in Dallas returned an indictment yesterday charging Robert David Neal, also known as Michael Skinner, also known as Albert Davis, with 6 counts of wire fraud, announced United States Attorney Richard B. Roper. Neal, a former resident of Trophy Club, Texas, is currently in federal custody because of a supervised release violation stemming from a May of 2002 federal felony conviction in the Northern District of Texas. Okay, that's where I got 2002. If convicted on all charges in this indictment, Neal, age 56, faces a statutory maximum sentence of 120 years. Wow! 120 years imprisonment, a $1.5 million fine, and restitution. The indictment also includes a forfeiture allegation which would require Robert David Neal to forfeit all of the illegal proceeds from the scheme, including $120,000 in United States currency, if convicted on any of the 6 counts alleged in the indictment. According to the indictment, from February to September 2005, Robert David Neal formed business entities such as Cambridge Capital Management Incorporated, Safety National Casualty Corporation, in order to conduct an insurance fraud scheme. Neal also used the names of American Lloyd's Life and Casualty Limited, Cambridge Benefits Group Limited, and ALLC to conduct his fraudulent scheme. Okay. I hope I'm not reading something. I think it is the same guy, but when I look up stuff on the internet on these guys that send me letters from prison, there's always a danger that I'll find somebody with the same name, that is not related to the guy that wrote me the letter. So I think this is the same guy, but I'm not. There's always a possibility I've found a write-up on the wrong guy, but I don't think it is. I think this is the same guy. All right. Anyway, as part of the scheme, Neal uses the aliases Michael Skinner, Albert Davis, and contacted and met consultants and executives from legitimate professional employers organizations, PEOs, to present a marketing pitch to sell them fraudulent workers' compensation insurance plans at below market prices. Neal furnished them quotes for premiums and certificates of coverage, and even created fraudulent insurance application forms and policies by piecing together legitimate insurance companies' forms. In the course of his fraudulent scheme, Neal hired a third-party administrator, RTW, in Bloomington, Minnesota, to process small claims filed by individuals supposedly covered under the policies. To further his scheme, Neal fraudulently represented that American Lloyd's Life and Casualty Limited Group, ALLC, included the wholly owned subsidiary Cambridge Benefits Group Limited, and that ALLC had the financial strength to underwrite a wide range of risk because it was controlled by 2 of the largest Lloyd's underwriting syndicates, managing assets in excess of $2.6 million. He further fraudulently represented that ALLC and its subsidiaries were leaders in the area of reinsurance throughout North America and the Caribbean, and that ALLC issued its first policy in 1964, and that Cambridge Benefits Group Limited was chartered in 1988 and served as the managing general underwriter for a number of insurance carriers throughout the United States. DSK Services of Homosassa, Florida Employees Consortium of Lombard, Illinois, and Risk Management Consultants of Arlington, Texas are legitimate businesses, PEOs, that were victims of Neal's fraud. In total, these companies wired more than $300,000 to Neal for what they considered to be premium payments for workers' compensation insurance. However, no legitimate insurance policy ever covered any of the small businesses that were supposedly insured through Neal. An indictment is an accusation by a federal grand jury, and a defendant is entitled to the presumption of innocence unless proven guilty. U.S. Attorney Roper praised the investigative efforts of the Federal Bureau of Investigation, who is leading the effort along with the assistance of the U.S. Department of Labor and the Texas Department of Insurance. The case is being prosecuted by Assistant United States Attorney Aaron Neely Cox. All right. There's another write-up in a place called Quatloose. They're also writing about him. When stuck in a hole, stop digging. This was written on 2014. Robert D. Neal, also known as David J. Nelson, digs deeper. The moderator on this blog, I guess, is Judge Roy Bean. All these people are probably getting paid by the government. I don't know. Kitchahota, September the 5th, 2014. When stuck in a hole, stop digging. It's an old and tired saying, but it's generally good advice to live by. Still, when one is 64 years old and in a hole that is already expected to keep you occupied until October of 2031, I suppose the temptation does arise to take the shortcut to China. After all, things can hardly get worse, right? What could possibly make things worse? Robert David Neal, federal inmate 151-51180, and disgruntled resident of Terre Haute Federal Correctional Institution, may be about to find out. It seems that spending this sort of time in a confined space gives you a lot of opportunities for legal research. Research, for example, on innovative interpretations of the UCC and magical properties of trust and the dark secret of strawman, the usual. And so he tried the good old foisted unilateral contract gambit on a rather unconventional target, the Federal Bureau of Prisons. I'm not going to post it here because it's over 120 pages, and I have to pay for Pacer access, and quite frankly, most of it is fairly usual soft-sit claptrap. You didn't convict me, you convicted my straw man, and since you didn't respond to this contract on my time frame, and according to my terms, you admit that you should immediately free me, and yada yada yada. And when the Federal Bureau of Investigations reneged on its clear obligations, he invoked the arbitration clause he had thoughtfully included in the contract. And when the Federal Bureau of Prisons outrageously refused to arbitrate, he did just what the People's Court always says. He didn't take the law into his own hands, he took him to court. Well, actually, he had already taken the law into his own hands, but better late than never, right? And when he inexplicably lost at the district court level, he appealed to the 7th Circuit, and there he encountered Diane P. Wood, Chief Judge. And, well, this happens. And then there's a long write-up about what the judge said. I'll put that link in the description bar too. Okay, there's another write-up here from the Department of Justice. Is there anybody outside, babe? Oh, yeah. Well, I may have to break off. We got a repair job going, but anyway. This is also from the Department of Justice, May the 17th, 2002. United States Attorney Jane J. Boyle announced today that Robert David Neal, a certified public accountant and resident of Trophy Club, Texas, pled guilty this morning in a federal court to presenting a false claim to the United States Treasury Department, Internal Revenue Service, in violation of Title 18 U.S.C. Section 287. He faces a maximum statutory imprisonment of 5 years and a $250,000 fine. He is scheduled to be sentenced by the Honorable United States District Judge Barbara M.G. Lynn on August 2, 2002. Robert David Neal had previously been indicted on 5 counts of filing false claims to the United States Treasury Department, and then later indicted for healthcare fraud in violation of Title 18 U.S.C. Section 1347. Neal was scheduled for trial next week before Judge Lynn on the 5-count false claims indictment. According to the factual resume filed in court, the false claim of $283,940 was the 1995 individual tax return for Robert and Deborah Neal. This 1995 return contained a false Form 1099 prepared by Neal, purportedly issued by the LMB Industries Incorporated to Robert D. Neal, claiming $438,692 in non-employee compensation and $438,692 in withheld taxes. As a result of Neal's false representations, IRS credited Neal's outstanding balance with the IRS in the amount of $283,940. According to the file plea agreement, the government agreed to dismiss the remaining 4 counts in the false claims indictment and the healthcare fraud indictment. Robert David Neal has agreed to voluntarily forfeit all licenses and to seek or attempt to reestablish licenses dealing with the business of insurance securities, financial advisement, and the like. Neal also agreed that he may be subject to pay restitution related to losses sustained by Dallas General Life Insurance Company as outlined in the healthcare fraud indictment. The indictment stated that the Dallas General Life Insurance Company's loss was a result of Neal's false representations and pretenses by omitting known adverse medical conditions on employer and employee applications for medical coverage. The investigation was conducted by special agents of the Internal Revenue Service, Criminal Investigation, trial attorneys Michael Yurkanen, Jr., D. Troy Sellers, and the United States Department of Justice Tax Division Criminal Enforcement Section, and the Assistant United States Attorney Michael Gill of the United States Attorney's Office, Northern District of Texas, prosecuted the case. We've also got a write-up here of from the FBI that I need to read, but I'm going to pause here for a second. All right, I'm going to read the first 4 letters that Robert David Neal sent me. He's in Terre Haute, Indiana. His release date is in 2031, so it's 15 years away. He sent me like the William Thweatt, Thweatt, William Thweatt plaintiff versus Colgemeyer, Dobbins, and Six Smith. I don't know, all kinds of legal write-ups, and looks like he's sending notices to David A. Berkebile, and he's sending notices to John Hogsett. He's sending notices to Charles E. Samuel Jr. Anyway, I think he's got me confused for some legal dude, because I'm not a legal guy. This stuff puts me to sleep, to be honest with you, but I think he's been in prison since 2002, so he's spending 30 years in prison. It looks like they got him on some sort of tax fraud. Anyway, this was written on November the 6th, 2016. I'm reading it on November the 16th. Dear Rudy, I am writing to you at the insistence of 2 friends, both of whom I will leave unnamed for now, who have told me you, your friends, and your other associates are true, strong Christian warriors, and who would be very interested in my personal ordeal. Unlike so many others in my situation who cannot even speak with clarity as to why they are in a similar situation as mine, often resorting to some sovereign citizen ideology or other diatribe, you will find that I always speak directly and am pragmatic and realistic, relying solely upon conclusively established and documented facts only. This said, I am one of 3 co-defendants in a federal civil case which has now reached a conclusion, i.e. deemed judgment via Rule 68 of the Federal Rules of Civil Procedure. Federal Rules of Civil Procedure. You can find the enclosed case through PACER as follows. Court, U.S. District Court of Nevada, Bailey v. Harris et al., case number 1:15-CV-2279. I am enclosing an excerpt from the Thweatt case, THWEAT, that is one of the many, many such similar cases that will tell you clearly and concisely the legal ramifications of Rule 68 court filing. These Rule 68 court filings are deemed by the federal courts to be no further actions needed to be taken to effectuate a final adjudication or a judgment, either by the courts or anyone else, i.e. the case is also forevermore and not subject to further arguments and appeals. Our case and its final resolution is conclusively supported by an extensive array of judicial admissions, confessions, which have been brought forward into the proceeding via Rule 36 of the Federal Rules of Civil Procedure. For clarity, I am also enclosing a true copy of the Rule 36, and you will see that the court rule is also deemed to be self-executing in nature. Our court case authenticates and ratifies some 116 sets of these Rule 36 judicial admissions forthcoming from 16 separate individuals. Some were served multiple sets on distinctly separate occasions. These court-adopted confessions entail 3,000 plus individual admissions, which totally eliminates forevermore any potential claim of an underhanded or fraudulent process. These Rule 36 judicial admissions are incorporated in 4 court-filed documents entitled Claim for Mandatory Judicial Notice, Federal Rules, EVID, numbers 1, 2, 3, and 4. I am sure you will agree after reviewing these documents that 1 Samuel 31, 4, and 5 is irrelevant in this situation. The final adjudication was effectuated through the court via the filing of a document entitled Offer of Judgment, Federal Rules of Civil Procedure 68, and 3 separate unconditional acceptances thereof. This offer of judgment spells out clearly the specific terms and conditions of this final adjudication, which, as I stated earlier, can never ever be challenged or disturbed via an appeal or further argument. It is the conclusion of the matters at hand, and thus the full faith and credit of the federal government. Article 4, Clause 1 of the U.S. Constitution is fully affixed thereto forevermore. The legal terms for this are res judicata and collateral estoppel. Enclosed, you will also find 2 sets of these court-sentenced and adopted Rule 36 judicial admissions, confessions, which historically and biographically speak to the truth and facts of the matter involving my situation with these despotic people. Nothing in here they have tacitly confessed to should surprise you at all in any way whatsoever. Both of these 2 sets have further authenticated and validated by the Federal Bureau of Prisons employee Leanne La Riva, as denoted in the court-filed claim for mandatory judicial notice, Federal Rules EVID 201C2 number 3. The confessions from David A. Berkebile will show you clearly that we truly have political prisoners in this country, and a legal process as established in the Constitution is not necessary predicate to incarcerate an innocent person when such a process is an inconvenient problem and not expedient. The second set of enclosed judicial admissions was forthcoming from Charles E. Samuels, Jr., the former and now retired director of the Federal Bureau of Prisons, FBOP, its chief executive officer. This second set of confessions will show the disdain which exists among the FBOP employees for any sense of justice, fair play, law, and order. In reviewing Samuel's admissions, please let me direct your attention as follows. A. Admissions number 4 through 19, these establish the actual existence, authenticity, validity, and legal binding nature of the 126-page express contract settlement by and between myself, the FBOP, and the United States dated December 9, 2009, which has been dishonored with impunity by these criminal FBOP employees who clearly have no regard whatsoever for the rule of law, i.e. true criminals of the worst kind. B. Admissions number 25, 26, 138, 140, and 157. These confessions establish the now fully adjudicated financial reparations which are due and payable for the United States Treasury, among others, as a direct result of the criminal activity of these FBOP employees. See also paragraphs 2A, C, D, plus paragraph 5 of the court-adopted offer of judgment. C. Admission number 117, this confesses our being the victim of an ongoing criminal RICO scheme at the hands of these criminal FBOP employees specifically designed to shut us up and keep us falsely in prison so they will not be called into account for their ongoing crimes. See also Samuel's admissions number 126 and 149. D. Admissions number 5 and 7, these confessions and documents, authentication in particular, confirm the actual issuance of a certificate of innocence from the U.S. Department of Justice, which establishes the fact that I was never a violator of any criminal statute, federal, state, municipal, or otherwise whatsoever. I am actually innocent of any such criminal behavior. C. 28 USCS and 2513A 1 and 2 and B. E. Admission number 143, 144, and 145, Samuel's confirmation that the clerk of the United States District Court of Northern Texas, Dallas, admittedly upon witnessing firsthand the events denoted in Berkebaul's admissions, refused to affix her official seal and counter-signature as required in 28 U.S.C.S. Section 1651 and 1691 to separate and distinct mitimus, i.e. order of commitment, and in so doing deprive the FBOP and its employees of any unlawful authority to deprive me of my personal liberty interest for even 1 minute. This Samuel's authenticated settlement, as also confirmed by the 75 other rendered their own confessions, addresses a number of other issues which are pertinent to most, if not all, victims of the federal criminal justice system as follows. A. Territorial jurisdiction. In accordance with 40 U.S.C.S. at sections 3111 and 3112, and supported by an extensive number of court cases, the territorial jurisdiction of the United States District Courts to adjudicate criminal activity is strictly limited to those events which occurred on real property upon which the federal government has formally accepted such jurisdiction from the various 50 states via specific contract and legislative act. This includes some of the federal buildings, some of the military bases, some of the national parks, etc. It is not simply everywhere these federal employees want to go and snatch someone up for prosecution. See also the 10th Amendment to the Constitution. That territorial jurisdiction thing is a big argument of Paul Hansen. I've heard this stuff before. B. Subject matter jurisdiction. Public Law 8772, which later became codified into Title 18 of the United States Code, was never voted on by the United States House of Representatives when a quorum was present. This documentary fact, drawn from the 1948 archives of the federal government itself, makes these entire matters null and void. About initio and absent a plea agreement contract deprives the United States District Courts of subject matters jurisdiction, since no valid criminal statute even exists. See also Hebrews 4:15 from our Holy Bible. C. In personam jurisdiction. When a person such as myself is not brought before the court to face his accusers and properly adjudicate the matter at hand, see the Berkebaul admissions. The United States District Courts, as per the 6th Amendment to the United States Constitution, lack in personam jurisdiction to decide any matter whatsoever as it relates to that individual. With this Nevada case now closed and the underlying issues now not subject to further contravention, this entire proceeding has evolved into the largest financial damage award for false imprisonment in American criminal judicial history. No other situation is even close. I'll leave it to you and the accountants to calculate the actual damage amounts so detailed in the court records, but they are huge, ongoing, and unquestionably headline grabbing. As you will also note when you review the court filed and adopted offer of judgment, this entire matter has now been ordered to arbitration pursuant to the Federal Arbitration Act of Title IX of the U.S. Code to resolve the only two remaining issues between the parties and their privities as follows. A. Requiring 13 of these rogue FBOP employees as detailed by the name in the offer of judgment to appear and produce their claimed statutory and constitutionally based authority upon which they are relying to trespass upon the full faith and credit of the United States itself to its peril. See Samuel's admissions number 14 and 150. And B. To evaluate, allocate, and assess the massive financial damages so recognized and adopted in the court records in total upon the criminal FBOP employees for their ongoing criminal trespass upon the United States itself via the legal doctrine of assumption. This will be devastating as per Samuel's admission number 166 and Exhibit A in the offer of judgment so denoted in paragraph 2D thereof. You should also take note that of these 13 named FBOP criminals called to the initial arbitration proceeding, Rule 36 judicial confessions already physically exist for 12 of them and filed in court records in the document entitled Claim for Mandatory Judicial Notice, Fed R.E. Vid 201C2 number 1. This documentary and evidentiary fact leaves these 12 criminals with no defense whatsoever for their ongoing criminal behavior. See also Samuel's admission number 146, 147, 148, and 154. Now, with the realization and full understanding of the landmark nature of these fully adjudicated facts, which truly affect not only the direct parties to this individual proceeding, but also so many other fellow Americans, i.e., we the people, as referenced in the preamble of the United States Constitution, so clearly and concisely laid out in the official records of this closed federal court case, we are in need of the following assistance. A. If you have an attorney, associate, or acquaintance who would be interested in navigating the United States declared conclusively established, court-adopted, and now fully adjudicated facts and issues through this mandatory and compulsory arbitration process, that assistance would be most welcome. I am currently without the financial resources to post an initial retainer deposit, but I would be more than willing to assign a percentage of these massive forthcoming financial reparations as compensation. C. Samuel's admission number 126 and 149. And B. I need this matter to be publicized as widely as possible. This would include any internet feed, such as YouTube, that you might have, as well as notices to the prison, legal news, the ACLU Prison Legal Project, CNN, Fox News, USA Today, and even the Associated Press wire service, among others. I can be easily reached through my power of attorney Kenneth Taylor, denoted, or by writing me back. Additionally, if you have an attorney who is willing to assist, I can also be spoken to via a privileged legal telephone call set up as follows. Care of Clint Swift, Case Manager, 812-238-1531, extension 3315. If Clint Swift is unresponsive, I can be reached through the warden of this institution, Stefan Julian, at the main prison number denoted above, 812-238-1531. All right, the fourth and final page. Well, God bless you, and good work that you and your associates are doing. Thank you in advance for reading this long letter and reviewing the enclosed documents and the closed case records. The court records contain or reference and adopt and authenticate some 1,200 plus pages of legally binding documents, which I have abbreviated for you herein. In any event, I will look forward to hearing back from you if you or your associate can be of any assistance in our continuing fight. Sincerely, and God bless. Care of Robert David Neal, Federal Corrections Institute, Terre Haute, Indiana. Carbon copy, Kenneth Taylor, Power of Attorney. 907 Cornerstone Place, North Las Vegas, Nevada, 89031, 702-912-3273. Enclosures. P.S. There are literally hundreds upon hundreds of federal court case decisions regarding these Rule 36 judicial admission confessions. One in particular, which is embodied in Switchmaster.com, Incorporated versus U.S. Music Corporation, 418 U.S. Supplemental 2D 812 CD, January 24, 2006, wherein the court explicitly stated as follows. Parties cannot attack issues of fact established in Rules 36, admissions by resisting a motion for summary judgment. Courts have held that affidavits and depositions entered in opposition to summary judgment that attempt to establish issues of fact cannot refute default admissions. Evidence consistent with a federal rules of civil procedure admission is properly excluded. That's the end of page 4, and then we go into his tweet. Looks like he has papers that have the tweet case. He has a paper that talks about fees. He has papers that looks like letters to David A. Berkebile. He has admissions, lots and lots of admissions. I guess people that admitted they did something wrong. Then he has a letter to John Hogsett, United States Attorney. He has a letter to Charles E. Samuel Jr., the former director of the Federal Bureau of Prisons. Looks like he's got even more admissions and copies of his USPS tracking numbers when he mailed it off, I guess for tracking purposes. All right, that is the case of, Robert David Neal. His Terre Haute BOP number is 15151180. This is Rudy Davis, and I make no claims to his innocence or guilt. I simply read the letter into YouTube, and I'll tell him that I read it into YouTube, and then whether he gets a lawyer to help him out is beyond me. I have no connection whatsoever to anybody in the legal realm, and so that's that. You guys make up your own mind.